So somebody at the state had to have made the decision, either unilaterally or collaboratively, not to pay these people. Mr. Schmidt, were you in any meeting, discussion, email chain, other than with counsel, where that was brought up and somebody in your presence decided not to pay those people? And if so, who was it? All right, welcome back, everyone. We're back on the record. Again, I apologize for the shortened lunch break, but we have ground to cover, and I want to make sure we get done today. All right, at this point, the court invites the state to call its next witness. Mr. Whitney, please proceed.
Certainly, Your Honor. Is Attorney Jones with us? I don't see her on the screen.
Yes, everyone's on.
Thank you, Your Honor. State would call as its next witness, Josh Marhevka.
Thank you very much. Good afternoon, sir. Can you hear the court?
Yes, Your Honor, I can hear.
Very good, thank you. Ms. Clerk, would you please administer the oath of witness?
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do swear.
Thank you very much, Mr. Marhevka. At this time, I invite the attorney for the state of Nevada to ask you some questions. Please proceed, Mr. Whitney or Mr. Ott.
Thank you, Your Honor. Mr. Marhevka, could you please state and then spell your last name for the record?
For the record, my name is Joshua Marhevka, Joshua Marhevka.
Thank you very much.
Thank you. Mr. Marhevka, where are you employed?
Currently, I work for the Employment Security Division.
And how long have you worked for the Employment Security Division?
18 months.
And what is your position with the division?
Management analyst.
And have you held that same position for 18 months?
Yes.
As management analyst, can you please just briefly tell us what your main job duties and responsibilities are?
I'm directly responsible for supporting the ESD administrator in the division. I'm involved in budget, fiscal, grant management, procurement, contracts, personnel tracking, inventory, regulation, legislation.
I would like to take a moment and show you what's been marked as Exhibit 16.
And Mr. Ott, are you able to pull that up?
Your Honor, I'm going to object to this exhibit.
What's the basis of the objection?
It is purported to be a statement regarding staffing at D.E.T.R, which I don't know why that is relevant to whether or not D.E.T.R actually paid people when they had an eligibility determination and fall under the court's order.
Well, remember, it's a two-part analysis for the court. One is whether there's been a failure to follow the court's order, and then the second is if the failure is legally justifiable, or if there's been substantial compliance. So to the extent that staffing levels may bear on one or more of those issues, the court finds it has relevance. So under the circumstances, the objection is overruled. Mr. Whitney, are you offering Exhibit 16 into evidence and to be published?
Yes, Your Honor.
Admitted. Go right ahead.
Thank you, Your Honor. Are you able to tell us then how many staff members that D.E.T.R had processing P.U.A claims between July 20th and July 28th of this year?
I'm sorry, Your Honor. Did you want me to share my screen as well?
Yes, please.
Thank you.
Yes, and is the exhibit coming up or?
It will be.
Okay, thank you. All right. This is an exhibit pertaining to overtime, specifically. It doesn't have a pertinent correlation to your question of how many staff that we've had employed in July.
Okay, did D.E.T.R hire additional? Do you know if D.E.T.R hired additional staff after July 22nd, 2000?
Yes, we did.
And was that additional staff to assist with processing P.U.A claims in order to comply with the court's order?
Yes, a significant amount was definitely dedicated to process P.U.A claims.
Are you able to tell us how much additional staff D.E.T.R hired after July 22nd of 2020 to?
Yes, this is a number from July through my most current tally of who we've brought on, but we've brought on an additional 102 staff from the 378 we had employed in July, bringing the total to 480. And just for clarity, this does also include part-time employees and employees or contractors that are working both UI and P.U.A. So it is not 480 full-time employees dedicated only to P.U.A. There is some part-time and mixture between UI and P.U.A.
Okay, thank you for that clarification. Can D.E.T.R just go out and hire extra staff on its own?
That's a yes and no question. If we have budgeted vacant PCNs, then yes, we can start the hiring process. If not, we must first obtain approval from the governor's finance office to release new PCNs for us to use. This can take some time as we need an approved staffing plan in place to be able to do that. These positions also must have a funding source, and they then would need to be built into the budget. So it's not necessarily a very timely process in a lot of cases.
Do you have an estimate of how much overtime was generated in order to comply with the court's order or mandate?
Directly related to the mandate, I do not.
Okay. Are you able to tell us then how much overtime was generated with just by D.E.T.R processing P.U.A and UI claims?
Yeah, absolutely. So actually the exhibit that's up right now, if you look into the top section, total hours overtime worked in agency 902, which is ESD since the beginning of COVID. So that's roughly, I believe the time frame is like March, very beginning, like second week of March is where we began to tally that based on our pay periods. That is 71,361 hours of overtime worked through the end of November.
And then how much did it cost to pay that overtime? Does the chart also show that?
The chart shows it broken down by month, but the total would be $2.8 million to fund that roughly 71,000 hours of overtime.
Thank you, Mr. Marhevka. Those are all the questions I have. Thank you.
Thank you. Examination by plaintiff. And Mr. Ott, go ahead and pull that exhibit down unless
Could you
they'd
leave
like
it up? Could we leave it up?
Okay, beg your pardon. Please leave it up, Mr. Ott.
Mr. Marhevka, do you know how many full-time equivalent employees are working on C.A.R.E.S Act administration? I believe you said there was part-time and full-time, but how many full-time employees you would have specific to the C.A.R.E.S Act?
I would have to look to get you an exact number of for that, but we can definitely provide that.
I guess here, let me ask you this question. You know, we don't want witnesses generally to speculate. You know, the best example of that is what's the weight of Mars in kilograms? Nobody knows. But if you can estimate based on your experience, knowledge, training, and common sense, could you give us a best estimate?
And I'm sorry, that wasn't including part-time employees. You only wanted full-time employees?
Well, full-time equivalent. So for instance, in the employment law context, you have part-time and full-time employees, but based on a 40-hour a week, 50 hours or 50 weeks per year, you have what's called a full-time equivalent. So you may have 20 full-time employees and 10 part-time, but that means you have 25 full-time equivalent. Does that make sense, the question I'm asking you?
Yeah, and actually, that actually makes a lot of sense. And the way that we've been tracking, and a lot of times we don't run into that unless it's somebody that we've contracted with, such as Maximus or some of the other state agency employees, such as the DWIS, group that is working with us. We haven't necessarily factored in, these five employees working 20 hours a week equals 100 hours. We haven't broken down the approximation that way.
Okay, I appreciate that. So my next question is that looking at this exhibit, and it shows the number of people here. And I asked you if that's just C.A.R.E.S Act people, but am I to assume that's just D.E.T.R employees in general that work on regular UI, any other, not just the C.A.R.E.S Act, or is this exhibit show specifically for C.A.R.E.S Act people?
So actually, I can give a little bit more insight and actually get back to the previous question as well with this. So in the last sample that we ran, this is D.E.T.R employed employees. So this is not counting contractors or people from other agencies that are also helping us. But ESD has, roughly 546 employees, and those would be FTEs that are either permanent or intermittent positions. And of that, 441 have worked overtime. Now, that sample also demonstrates that you could have had somebody in March, April, or May work overtime, and they haven't worked it recently. So across the board, roughly, I don't know what that is, 85% of our employees have worked overtime of our entire pool.
Okay, since I'm not on screen share, I'm gonna point to, in March you had, is that 470 or 4,745, is that hours?
Yes.
And then in April, it shot up to 8,549.95. Thank you. And so I'm assuming that's because the P.U.A site went live. Is that correct?
Well, a couple combinations. Obviously, the first roughly 2 weeks of March, we were not in pandemic, so the overtime was definitely not occurring. And then overtime would then be ramping up because of the start of pandemic through March, and getting up to the higher rates that you see between 8,000 and 12,000 ongoing. And yes, P.U.A definitely has an impact on that number.
And then we're circled there. We have May, it jumped up to 10,000. Why do you believe it jumped up to 10,000 there?
There could be several reasons, but just the amount of claims, also us trying to get these other funding sources enacted and in place and start paying people out. Just because that we were awarded the C.A.R.E.S Act funding doesn't mean that we could immediately deploy that to the claimant's bank accounts. So there does take some time with programming, development, requirements gathering, testing. These factors are all needed to basically launch the C.A.R.E.S Act money into production and pay people out. And
so, I apologize. I didn't mean to interrupt.
Oh no, that's fine.
Right underneath the circle there, then it dropped about 3,000 hours. So if we look at June and July, they're roughly similar. And that was a drop. And I believe you testified because that May period was getting everything updated. So would you say June and July were a normal C.A.R.E.S Act pandemic staffing level?
Yeah, as far as normal a crisis can be, yes.
And then in August, it jumps up to 12,000. Do you have any information on why it jumped up to 12,000 there?
I know that we still continue to have a high need of resources needed to continue to pay people out and to work and do programming. I am not entirely sure when the lost wages went into effect, but I believe it was somewhere around the end of August that we started planning for that, and that could be a potential reasoning for the spike.
You said something about you had payment issues. How many people does it take to pay out claims, to actually process the claim, process the check, so to speak?
I don't know. I don't have that information.
Okay.
I'm more on the administration side more than I am the actual claims processing side.
Okay, and we see here in September, they dropped down about 5,000. Do you know why there was such a large drop there?
The only thing I can think of is that the bulk of planning for lost wages had maybe been done. It definitely is leveled out there. I don't really have any other further insight of what would have caused that.
And then in October, we dropped down about another 500. And now we're at November, we're about at 55,000, which seems to be, less than 1,000 hours to pre-pandemic level. Would you concur?
Yeah, yes, I do concur. And, at this point we have processed, tens of thousands of claims. And so things are seemingly leveling out. I'm not saying that they're quieting down, but we should see this trend to continue.
Does this figure include the people that are conducting appeals?
If there was appeal staff coding time and working overtime, then yes, it would. But I don't have that breakdown in front of me.
Okay, I'd like to enter into or talk about. I'm done with that exhibit. I don't believe we've had exhibit number 9 entered into the record yet, which is Plaintiffs Exhibit 9, which is UIPL letter number 2820. I would like to chat about that.
All right. Plaintiff has offered Exhibit 9. Does the state have any objection?
Your Honor, no objection to admitting Exhibit 9. Thank you.
Thank you. It's admitted. You may publish and proceed.
Mr. Marhevka, can you see that it says Plaintiffs Petitioners Exhibit 9, just a cover sheet?
Yes, I can.
And Mr. Whitney, can you see it? And Your Honor's giving me a thumbs up.
I can, thank you.
I would like to direct your attention to page 6.
Well, let's identify what the document.
I apologize. Yes.
That's
So
right.
this is Plaintiffs Exhibit number 9. It's UIPL number 2820, and it's dated August 31st, 2020. I'd like to draw your attention to, I'm going to get this a little bit smaller here for us. We're going to go to page 6. I've highlighted some sections here, particularly number 5, funding for states to address fraud in the P.U.A and P.U.A program. The department is providing a total of $100 million in administrative funding targeted specifically at addressing fraud and identity theft. The use of the funds here says states are permitted to use this targeted funding for staff or contract services to conduct fraud investigations. When we were talking about your total hours in that first exhibit, did that include fraud investigation?
Yeah, that absolutely would. And I wasn't thinking of it at the time, but it was somewhere around August as well that we started working with ID.me and really getting into the more fraud prevention side. As well as you all know, the rapid response team got brought in. So there would be, that would definitely be another attribute of the spike. And yes, for anyone working fraud for the Employment Security Division would 100% be included in that.
And they're, according to this, it seems that they're 100% federally funded. Is that correct?
The Employment Security Division is 100% federally funded.
Okay, I don't have any other questions.
Thank you, Mr. Whitney. Anything else for this witness?
Just one quick question. Mr. Marhevka, you said the Employment Security Division was 100% federally funded?
With the exclusion of the Commission on Post-Secondary Education, they do have a small bit of funding that comes from the general fund, but the major budget accounts in the Employment Security Division, the workforce side and the UI side, all are federally funded.
Now, do you happen to know when, after the state entered into the C.A.R.E.S Act, did the state have to provide any money first before it was reimbursed by the federal government? Do you happen to know if that was the case or not?
I don't know that for sure how the funding worked. That would be something our financial management division took care of.
Thank you, Mr. Marhevka. Sorry, I'm butchering your name. Thank you, Mr. Marhevka. I have no further questions.
Thank you. I just have one question. You said your job title before, but I think I missed it. Could you tell the court that again, please?
Yes, Your Honor. I'm a management analyst.
So generally, can you describe for the court what your job description is?
Yeah, I do everything from legislation, regulations, fiscal analysis, employee tracking, inventory, if I hadn't said that already, procurement, contracts, solicitation.
Okay. And then at or about the time the court issued its order of mandate to the state, were you made aware of it?
I was made aware of the court case, but not so much of any of the particulars about it.
All right. Do you know why we're here today?
I believe so, yes.
What's your understanding?
That the department is being sued for not paying out a claimant.
Okay. I appreciate your being here today, sir. Thank you for the work you're doing. The court thanks and excuses you and wishes you a safe and happy holiday season.
All right, thank you.
You can log off. You're certainly welcome to observe the rest of the hearing today, but of course that's up to you. All right, Mr. Gaynor, please, thank you. Mr. Whitney, please call the state's next witness.
Thank you, Your Honor. The state would call Mr. Brian Bracken.
Okay. Mr. Bracken, good afternoon. Can you hear the court?
Yes, sir.
Would you please spell your last name?
It's actually Bracken, B-R-A-C-K-E-N.
Okay, Mr. Bracken, thank you. Ms. Clerk, are you able to please change the way Mr. Bracken has identified himself?
Yes, Your Honor, I'm doing that now.
All right, thank you. All right, and then once you do that, if you would please administer the oath of witness to Mr. Bracken.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, Mr. Bracken. You may put your hand down. Mr. Whitney, you may proceed.
Thank you, Your Honor. Mr. Bracken, where are you? I'm sorry. Are you employed right now?
Currently, I work on contract for D.E.T.R. I'm performing adjudication work on contract. I'm performing in regular unemployment insurance on adjudication.
Okay. And how long have you been doing the contract work with D.E.T.R?
Well, on this particular contract, it started when I retired for a second time on September 11th. So I've been doing this contract since that time. Previous to that, I was under contract as a deputy administrator overseeing P.U.A. claim operations.
Now, previous to the time when you were the deputy administrator, were you employed by D.E.T.R?
Yes, sir.
Okay. And are you able to tell us how long you were employed by D.E.T.R?
Approximately 25 years.
And was your position with the Employment Security Division during that time?
That's correct.
And
I retired initially August of 2019.
And when you retired, can you please tell us what position you held at that time?
I was working at that time as a business process analyst 3, which is a managerial business process analyst. Prior to that, I was an unemployment insurance program chief for the support services office. Also held various titles as appeals chief for unemployment insurance and operations manager.
Now, after you came back from retirement, can you just describe for us your main job duties and responsibilities?
Initially in March, around March 15th or 16th, I was contacted by the administrator, Gone, asked if I was willing to come out of retirement and work for D.E.T.R under contract and help manage claim operations in the unemployment insurance call center in Carson City, or just regular unemployment insurance initially.
And did that change?
Yes, around the first week of May of this year, that changed. I was contacted by then Administrator Gaughan, asked if I could pick up oversight of P.U.A operations, as it was languishing a bit and needed to be stood up within the next week or two. We wanted it stood up by mid-May of 2020.
Now, are you aware of the Amethyst Payne case involving D.E.T.R that's in Washoe County?
You know, I'm not aware of the specific details other than what I've reviewed, you know, for this in preparation for the hearing today. You know, and based on testimony that I've heard, you know, I have some familiarity based on that. I was not personally involved with it previously. I could answer some general questions about it, but.
Now, were you aware then, were you aware then of the court's order of mandate from July 22nd?
Yes, sir. I was familiar with it. I was aware of it.
Okay. Then, was it possible for D.E.T.R to fully comply with the court's order of mandate by July 28th of 2020?
That's kind of a complex. Was it technically possible? Probably. It would take some work working with the vendor, and it would take an administrative decision just to go ahead and give authority to blanket release every P.U.A claim that was previously held. I did not maintain that authority to do that, sir.
You mentioned blanket release of P.U.A claim. What does that mean?
What that means is that we would have to work with the vendor of the program of the application, which was GSOL, Geographical Solutions Incorporated, GSI, and provide them, after we did some vetting and queries and whatnot to determine that population, to say that, look, we're just simply going to remove every stop and hold on these claims and release them for payment of benefits, and ignore U.S. Department of Labor guidance regarding integrity of the program and improper payment, and just say, look, let's just pay all these people.
Hold on. Mr. Bracken, I appreciate your candor, and obviously you have a significant many years of experience, but it offends the court a little bit the way you characterized compliance with the court order would lead to that level of process. I mean, let's get real here. The court was very specific, consistent with United Supreme Court guiding and binding jurisprudence that the court extrapolated to the facts here. And the court was not ordering, and has never ordered, people to be paid who did not deserve to be paid. The court did not order, or is not ordering, people who have clear and convincing evidence of fraud embedded in their application. The court did not order, or would not order, knowing violation of any federal guidance. So let's make sure we're using the right terms here. The court was very specific. The order of mandate said, if payments had begun, now let's make sure we understand that. If payments had begun, they could not be stopped unless and until one of these four reasons triggered payments to be stopped. The court didn't order payments to begin. The court didn't order payments to be made to people who were fraudulently attempting to obtain benefits. The court didn't order the department to blanket pay anybody. That was not the court's order. And the court, frankly, would just remind both sides here that the court narrowly tailored its order to a couple different buckets of people that the court found federal law required payments to be made. As to the many other requests by the plaintiffs, the court at that time declined to order the state to move forward, and then later ultimately declined fully and finally to decline to order that. So we're all clear here. The court narrowly tailored the order to be consistent with guiding United States Supreme Court precedents. That precedence is more binding and persuasive on this court than is Department of Labor letters or opinions. We're talking about the United States Supreme Court case in Java. That was the genesis of the court's order. It was narrowly tailored. And the question today is if the state of Nevada has failed without legal excuse to comply or at least substantially comply with the court's order. So that's why we're here. And I would just remind everybody to bear that in mind. Mr. Whitney, next question, please.
Thank you, Your Honor. So would the Employment Security Division have been able to identify the different groups of people, groups of claimants that fell within the court's order of mandate by July 28th, 2020?
I can't say with certainty we would have been able to do it by July 28th because obviously it wasn't completed, but we were working towards that after the order from the court. With all due respect, Judge, Your Honor, I did not intend to disrespect anyone within the court or what your ruling was. I was simply answering the question of counsel. And D.E.T.R did have the opinion, based on our review and analysis, that there was clear and convincing high rate of fraudulent activity across the P.U.A program. So I just want to be frank with you, sir. No disrespect meant.
Thank you. Please proceed, Mr. Whitney.
Thank you, Your Honor. So are you able to tell us how much staff you had working with you between July 22nd and July 28th working on these P.U.A claims?
Directly at my disposal, approximately at that time. And of course I had, I could make requests for staff. Those had to be approved by the administrator to work with the P.U.A program. I had approximately maybe 16 to 20 full-time individuals working across P.U.A. That would be P.U.A adjudication and P.U.A investigations that were able to review these claims once we identified our population through queries that were requested based on the court's order. These individuals that payments were stopped, and then we would have to then drill down and determine whether or not there was any fraudulent hallmarks or activities on those claims. And claims were stopped for various reasons, Your Honor. They were stopped for investigative process holds. They were stopped based on answers that claimants provided on their weekly certifications regarding receipt of a pension or some other form of payment. They were stopped based on jobs or cross matches that were run by the agency for detecting other UI eligibility, and based on our guidelines from the U.S. Department of Labor that we couldn't pay those individuals if they had eligibility for other programs, whether it be in the state of Nevada or other states. And with all due respect and understanding of your order. So, D.E.T.R maintains a fiduciary responsibility to maintain the integrity of the program and to ensure that we're not issuing improper payments and we're subject to sanctions, by the U.S. Department of Labor, and holding of funding if we're not in compliance. We pay individuals that we know are filing improperly.
Mr. Bracken, you just mentioned sanctions by DOL and withholding of funding if individuals are paid improperly. When you say paid improperly, could you be more specific? What does that mean?
That could be an individual that was a fraudulent claimant that we paid, that we knowingly, we had information that it was fraudulent and we disregarded that and paid it anyways. It could be that we knowingly had information that that person was eligible for a regular Nevada unemployment claim, or, for example, regular unemployment claims in the state of California, and we went ahead and paid it anyways under the P.U.A program, knowing it not to be correct. And DOL conducts their reviews, on a quarterly basis of program integrity. And, as my previous experience as the program chief for unemployment insurance support services, D.E.T.R has been under corrective action plans and determined to be previously an at-risk state for violations or not to be in compliance with Department of Labor guidance. And that part of those sanctions as a result of that can lead to withholding of funding or reimbursement for program payments that D.E.T.R makes improperly. Yes, it can lead to that.
Are there other sanctions other than withholding a payment that D.E.T.R can face for improper payment?
Oh, we could be held to report to the DOL quarterly on a range of issues or elements that we were found not to be in compliance with across the program, and we would have to provide that response. And they would provide us a spreadsheet and list all the places where D.E.T.R was not in compliance, and D.E.T.R would have to provide that response. It's referred to as an SQSP process, and provide that response to the U.S. Department of Labor Regional Office and with a copy to the main office in Washington, D.C. to state why we were not in compliance, and to also cite our how we were going to rectify that and to be in compliance in the future. So yeah, we've been under those in the past, and we are subject to those if we're found to be not in compliance.
Now, when you said improper payment, would improper payment be considered payments that are in violation of the U-Pools?
Correct. DOL would find that you were in violation or you didn't adhere to the standards of the guidance, and therefore that they're going to issue whatever that sanction may be, and that's up to their discretion based on the administrator or director of the U.S. Department of Labor, and then we would have to adhere to any sort of penalties that they would issue.
Now, you had mentioned, if I heard you correctly, you had about approximately 16 to 20 staff members working for you in the time period between approximately July 22nd to July 28th.
Yeah, and we're talking several months back. I can't recall specifically. It was about that number. I had a P.U.A team that fluctuated, that worked on just P.U.A adjudication. They were also adjudicators that were experienced in the U.I application. So they were kind of a hybrid, or they could cross both programs. And that was part of our review in order to know whether or not somebody qualified for P.U.A or regular UI. They could do all of that. And then we utilized the ESD investigative office staff that was managed by Mr. Shane Ricketts. And the investigative staff would participate in these reviews as well, because of the fact that there were investigative process holds or IP holds for various reasons based on hallmarks on either their IP address, their physical address, or other attributes attached to that claim that the Integrity Office had identified as potentially fraudulent. And so we were working in cooperation with that group and utilizing their staff.
And so with a staff of that small a staff, I'm not sure if I heard your response correctly. If I heard your response when I asked you, would your staff in that time period between July 22nd and July 28th, with your staff of people that you had, would you even have been able to identify the different groups of claimants that fell within the course order mandate in that 6-day period or 7-day period?
And to be frank, sir, no, we would not. There was no way we'd be able to do that. It takes, a couple of business days to formulate the queries. And then once we've determined the type of query that we need to request, had to work with our provider for the application, GSI, in order for them to facilitate that. We also worked with our ESD internal research and analysis office and Mr. Schmidt to perform queries for us as well. But those took a matter of, maybe 2 to 3 days, or, dependent upon what sort of cooperation or availability was there for resources with either RNA staff or GSI. And then once we received those queries, I would have to direct my management staff to distribute those queries for review amongst that 16 to 20 staff members. And at that time, we were able to review approximately 500 to 700 claims per day, sometimes more, sometimes less. It depended on whether or not there was conflicting priorities. We're also trying to stand up the appeals application at that point too. And so I had a small group of people with a lot of job requirements or duties that were expected to be performed. And so we certainly did the best we could. There was no willful disregard of any court order. I can say that with certainty. I was never told to disregard any court order, and I never took it upon myself to blatantly or directly or purposely disregard a court order.
Thank you, Mr. Bracken. Those are all the questions I have for you. Thank you.
That would require proof by very significant evidence.
I want them to be present, and I want to be able to see them throughout these proceedings.
You both did a good job bringing all this to my attention.
I'm going to make a record about you in a minute. You need to sit down and be quiet.
The court finds in the best interest of the minor child and makes the following findings.
For the record, I don't say these things to hear myself talk.
An absolute decree of divorce is granted.
By September 6th, you will pay $6,000 of what is due.
Good afternoon, Mr. Bracken. Can you please tell me who at D.E.T.R determines the parameters or the definition of clear and convincing evidence of fraud?
Well, I mean, that would be based on administrative level staff in conjunction and meeting in conference with our integrity office. And certainly there were a lot of hallmarks present with these P.U.A claims that appeared to be potentially fraudulent. I know that Ms. Allender worked for me under my direction, as she testified previously today. And she would be responsible for conducting reviews of P.U.A claims along with other staff that were assigned. And we were running at the rate of a good, most days, 9 out of 10 P.U.A claims that we reviewed had elements that have been identified as fraudulent based on their email address, their address, location, their physical address, based on telephone numbers and other attributes that were identified from other states and from our vendor that were also hitting other states.
I don't want to cut you off, but my question was pretty simple, and that who determines what clear and convincing evidence of fraud was, and I believe you said that was at administrative level. I think you also testified. I have that here. You testified that you were looking at 700 per day fraud determinations, but you just said you had 9 out of 10 had an element of fraud. So you had 700. You looked at 700 per day. I didn't understand.
I didn't state that, or maybe my testimony was misunderstood. I testified that our P.U.A team that were assigned to these query lists of the identified claimants were able to review 500 to 700 claims per day. Now, during those days, were there many claims that we released for payment based on review of the claim to ensure that they had uploaded their identification documents, which we had sent out on messaging to claimants. If they met all the elements of being a legitimate claim, we released those as one-offs as they came across those. The adjudication staff would release those claims for payment.
Do you have a percentage of that 500 to 700 which were released?
No, I do not.
Do you know how many people had start-stops that were issued fraud determinations?
I'm sorry, what was the question, ma'am?
Sure. Do you have a number of people that had start-stops that were issued fraud determinations?
I do not know of any individuals that were issued specific fraud determinations prior to my leaving my oversight position with D.E.T.R. I left there on September 11th, so I really have no knowledge of P.U.A operations since September 11th. I just want that stated on the record.
Okay. And in your experience while you're at D.E.T.R, you said 500 to 700 per day. Do you know how many of those people were afforded an opportunity to be heard?
Well, what happened with those, ma'am, is our adjudicators and investigative staff were reviewing those, and through documents or through communications in the P.U.A portal, and they were able to communicate with those claimants. So let's say, for instance, they came across a claim where, they had provided, their identification documents appeared to be legitimate. They had, met the eligibility requirements that we've set forth. And so they would simply release the claim. Now, in reviewing that claim, if that adjudicator found that there were missing documents, they hadn't complied, for whatever reason, they didn't previously receive the blast message, our adjudicators would be in contact with the individuals that they were reviewing through the portal and say, hey, hi, look, I'm reviewing your claim. I see that you didn't upload, XYZ ABC. Could you please provide that documentation? I'm going to give you 48 business hours, which is a US DOL standard for providing, reasonable contact or reasonable time for an individual to respond to a claim request. And so they would notify them through the portal and say, please provide that information so we can make a determination on your claim. So that was done on those.
Okay, so are those people that had a denial, or it was just a claim being reviewed?
Claims were being reviewed. If there was a denial for a determination that was justified for any particular reason under unemployment insurance law or based on the guidance from the USDOL, staff was instructed to issue those determinations, ma'am. when they found someone that was not in compliance and warranted a determination. So they were directed to do that. Can I also continue to state that they were directed to clean up the claim for what, if let's say this has been discussed previously with the court. I know that, we have people that had regular UI eligibility, we have people with P.U.A eligibility. We got to pay them in the proper program. That staff was trained in a manner that which when they were reviewing those, that person had regular UI eligibility. They were instructed and directed to take what necessary action there was needed to clean up that claim and place them on the proper UI claim and contact them and tell them, look, we're moving you to regular UI. This is what you need to do. So they were given that direction.
Mr. Bracken, I'm going to pull us back here. We're specifically talking today about people who had start stops. You've thrown out a number of 500 to 700 per day. I don't think that's start stop people. I think that's the whole universe of UI and P.U.A. Am I correct in that?
No, ma'am, that's not. No, that is start. Those are, we conducted queries. We gathered that population of individuals based on the criteria set forth by the court. We were given these lists with thousands of P.U.A claimants, and then they would be distributed out to staff and say, look, work these lists, and these were P.U.A claimants that were stopped.
So there was 500 to 700 per day of people that had P.U.A claims that had start stops.
That were being reviewed, previously stopped, okay?
And then they were reviewed.
Reason.
Okay.
And then we were reviewing those to see if we could issue payment.
But you're unable to tell the court how many people had start stops that were issued fraud determinations. Is that correct?
There were no, well, I stated on the record, there were no fraud determinations issued at that point, ma'am.
And you don't from
Well,
September.
hold on. I want to make sure I understand fully, because Mr. Bracken, I mean, you've indicated there were indicia. There was concern. There was evidence. At least that's the gist of what I'm getting. But and so do I have that right so far? There were some tells that might lead to a fraud determination that you and your staff were seeing fairly commonly on a daily basis. Is that fair?
Well, let me clarify that. Yeah, that's fair. That there were hallmarks or tells, as you stated, Your Honor, that indicated that there was a high potential for fraudulent activity in the program and with the claims that we were looking at. Yes.
All right. Now, Ms. Jones is trying to narrow that down to people who received a fraud determination letter, email, correspondence, communication consistent with Department of Labor guidelines or other state or federal law. Ms. Jones, do I have it right that that's the area of questions you're going in right now?
Yes, Your Honor.
All right. So the witness has testified, Mr. Bracken has testified that to his recollection, there were none of those. There were, however, a considerable percentage of hallmarks that were of concern to those reviewing the benefit requests. All right. That's what the court's taking away from that. All right.
With the court's allowance, Your Honor, I want to clarify that.
Go ahead.
As far as a stated fraud determination, sir, which has different language and different reference to law, were any of those issued per se? No, sir. Based up until the time that I departed the agency in my position as deputy administrator of the P.U.A program. Were there determinations issued to those individuals because they didn't meet eligibility requirements based on we couldn't validate their identity, or they didn't comply with our eligibility requirements that we had asked them to comply with, sir? Yes, those determinations were issued. But a specific fraud determination, sir, had not been issued at that point.
All right. So then with relevance to this hearing, the bucket of people that you've just described that were issued determinations that there were concerns or issues or problems, the unique subset of all claimants that the court's order spoke to are those groups of people for whom payments began and then they stopped. And because those people in the court's estimation, again, the court's understanding of guiding jurisprudence from high above is that you're not allowed to stop the payments absent one of the criteria the court identified in its order of mandate. We're not talking about starting payments initially if the department had concern. We're not talking about people who clearly were attempting to defraud the state of Nevada. We're talking about those that receive payments because the United States Supreme Court has determined that those people have different rights than people that had not had payments begin. So Ms. Jones' questions about was there a fraud determination, because the takeaway for the court is if such determinations were sent and received, those people then have the right to protest or engage or attempt to explain away the concerns that the state was had paused the payments. But absent that, then depending on who you believe, the court's order should have required payments to continue, notwithstanding the hallmarks or the tells or the concern, unless the concern rose to a heightened level, clear and convincing evidence, which most of us know, and those that are not legally trained should know by virtue of their counsel, means more than just 50%. It needs to be considerably more than that to stop the payments. So you and Ms. Jones can spar around the language, but for the court, Mr. Bracken, I guess what I would like to know is, did anyone who had to your knowledge, did anyone who had payments begun have their payments stopped because D.E.T.R was concerned with hallmarks of fraud, but that fraud did not arise to the level of much more likely than not? That's really what I would like to know. Do you have an opinion on that?
Well, my opinion is, sir, we're really, as Ms. Jones referenced in prior testimony and UPLs, which I'm well aware of, for unemployment insurance, is that a real determination of fraud, to make that determination can't be until we've completed an investigation and make a determination whether it was willful, whether it was inadvertent, whatnot. There has to be an investigation that takes place. Certainly, did D.E.T.R feel there was clear and convincing of evidence of fraud across the program? Yes, sir, without question. I'm going to go back in time a little bit. There were, individuals that were receiving unemployment, P.U.A benefits, excuse me. And then we implicated a security measure in cooperation with the GSI. It was called a two-factor authentication. This may have come up previously in hearing testimony and other sessions, in which there was an issue where claimants, when we implemented that two-factor authentication, they had been receiving benefits. They had to do something. They had to receive some sort of a text code or email code, and then provide that information in order to continue filing their claim. It was two-pronged. There was a problem with the application itself that we got fixed shortly thereafter. And it was also claimants that couldn't authenticate for one reason or another based on that message that was sent to them either through email or their phone number on record. And so those held claims that were previously being paid, sir. And those created investigative process holds on there, which I didn't have oversight of that, the investigative process holds. That was done by the investigative office. So what I tried to explain earlier in my testimony, Your Honor, is that there were various reasons why these individuals that were being paid P.U.A benefits were stopped, subsequently stopped. And then, there was review processes that needed to take place and say, why were they stopped? Can we release it or fix it, and comply with the order and continue payment?
Okay.
Does that make sense, Your Honor?
It does. Thank you. So Ms. Jones, what's the beef the plaintiffs have with that approach? Because, just some modest concern with some of the descriptors used to apply for benefits, that's not what Mr. Bracken's testifying to. He's testifying that there was some concern, and then there was an attempt, for example, to email or text someone and have them have to, respond that it's really them, and they can, so if they've attempted to get people to confirm that they are who they say they are, and done a couple different things and still aren't receiving assurance, why would the plaintiff's counsel here have some concern that they're violating that portion of the court's order of mandate? Seems to the court that might arise to a preliminary evidence of clear and convincing.
Sure.
Why do you think differently, Ms. Jones?
If Your Honor will allow me to bring back up on the screen exhibit number 8, UIPL
Yes.
0116. Your Honor, can you see plaintiff's exhibit
Yes.
number 8?
Yes.
Mr. Whitney?
Yes, thank you.
Okay, I would like to go to page 6. You were talking about a blast or an email or something like that. That's how you contacted people. Is that correct?
The blast messaging was done and was also embedded in the application. That's correct.
Okay, so under the UIPL, when you're making a determination for fraud, it is incumbent upon a state to make further contact with the individual, inform him or her of the conflict, and allow an opportunity for rebuttal. Because such factual conflicts require the state agency to make a determination of credibility and intent, determinations of fraud must be made by agency staff. The determination may not be made by an automated system. And so that's where plaintiffs take issue with this email blast or having people do ID me or something else like that. And if they fail to do so, and there could be legitimate reasons, they don't have their phone anymore. They can't pay for it. Their email shut down.
Well, hold on. This is closing argument. So the question to the witness is, how does he reconcile what his experience was when he was there through September 11th was with what this guidance suggests should be done? Were they consistent? Were they inconsistent? And if inconsistent, how come? I guess that would be the question.
Thank you, Your Honor. Yes.
Ma'am, Ms. Jones, what's the specific question you would like me to answer?
How did your explanation of providing an automated ID me or response or something like that escalate claimants who had issues with IP or something like that to a clear and convincing badges or evidence of fraud such that their payments should be stopped?
Well, we only have so many tools at our disposal and actual physical resources, workers to review. So I'm sure you do business with a bank, credit card company, a car loan provider that has a two-factor authentication. I know I do personally. That sends me a code. If I don't respond or don't authenticate based on that code, I'm not allowed in the system. I'm not identified as that owner or user of that particular account. So we were utilizing that type of functionality to assist with this mass number of individuals that we had to deal with, unprecedented, that which D.E.T.R has never seen the likes of, and a staff that was overwhelmed and overrun. This has all been said before. And we had to revert to technology in order to assist us in identifying individuals or seeing if that individual is actually who they say they are based on our best availability of resource, and then move forward. Now, if individual stops were put on a claim based on our inability to identify or validate someone, obviously, those would need to be scheduled or handled by a fraud investigator or our staff member at a later time to review, adjudicate, for lack of a better terminology. So based on sheer numbers, ma'am, not to say that D.E.T.R isn't going to do those investigations or review those claims, but there's a finite amount of people that we have at our disposal to do those investigations. And you're talking about hundreds of thousands of individuals. With all due respect to the court, that does take a bit of time to do that. And, even though we've hired, D.E.T.R's hired individuals, extra workers and allowance for overtime, there's a backlog of work. I'm working UI claims now, and there's still a backlog of UI claims. So the backlog is there. We're doing our best that we can to work through it. That's basically all that I can state. Were those investigations going to take place, ma'am? Yes. When they were going to take place, I cannot testify to that. I did not oversee the investigative office.
So the hundreds of thousands of people that have failed to receive benefits just have to wait.
Well, that's argument. So, Ms. Jones.
That, Your Honor. I have no further questions.
All right, thank you. Mr. Whitney, any further questions of Mr. Bracken?
Thank you, Your Honor. Yes, just a few more. Thank you. Mr. Bracken, are you familiar with, Ms. Jones has been asking you about UPOL 01-16. Are you familiar with that UPOL outside of this court hearing?
I'm familiar with all UPOLs that were issued, sir, in regards to the P.U.A application. That's a yes.
The language, the determination may not be made by an automated system. What does the determination, what does that mean to you when that particular sentence? Does that mean that you cannot send out a blast concerning a person's identification?
Oh, I mean, those blasts, sir, were not determinations. Those were communications to P.U.A claimants to tell them what the eligibility requirements were and what they needed to do to comply with that review. That in and of itself, sir, those blasts were not a determination. Now, before any sort of mass determinations may have been issued by the agency, those were done after reviews were conducted based on information on those claims. And it was determined that those individuals didn't meet whatever the requirements were for that particular issue related to either P.U.A or unemployment, and were issued determinations on that. So did the vendor have the ability to say, hey, look, we reviewed 2,000 claims. These individuals we reviewed, they either they haven't complied with the requirement or whatever it was, issue the determination and send them all out. Those were done only after a review was conducted, and those individuals were contacted or given the opportunity to provide information back to us that was being required or asked of them. And then if they didn't comply, then there was a job run to issue determinations en masse. Does that answer your question, sir?
Yeah, pretty much. Thank you. You'd also, I'm hoping I heard your testimony correctly. You mentioned hallmarks of fraud, I believe. Is that correct?
Yes, sir. I don't really want to get into the specifics of those hallmarks. I mean, there were some that were related to what their email address ended in or how they formulated their.
Well, we don't want to telegraph to the bad guys how they can beat the system by identifying all the ways we caught them in fraudulent activity, and the court's not encouraging that. I want to just continually want to circle back here, because whether we call it hallmark, indicia, a tell, a strong suspicion, the court has to determine if it arises to a heightened standard of clear and convincing, which is a lot of hallmarks, a lot of indicia, or else according to the court order, after a lot of thought and review of the law, those people need to be paid until and unless a determination is more properly made or they have an opportunity to appeal and dispute. So that's really where we're going. But Mr. Whitney, I didn't mean to cut you off there, but that's what the court's takeaway is from what Mr. Bracken has testified to already.
Thank you, Your Honor. Just one more quick question to Mr. Bracken. Mr. Bracken, you testified that you estimated that your team was reviewing between 500 and 700 P.U.A claims where payment had been stopped. Is that correct, per day between July 22nd and July 28th?
Yeah, that's correct, sir. That's what I testified to.
Are you able to remember how many total P.U.A claims that you and your team began to review? What that number was?
Sir, I do not. I can tell you that we looked at thousands of claims per week, and Your Honor, that we've provided testimony to the court that D.E.T.R has released in mass bunches of individuals that were held for payment that we validated and released payment on in the thousands. I know we didn't fully comply with the order, sir. I understand that, but we were working to the best of our ability, sir, to be in compliance. And we were working to facilitate payment of benefits. But I can't give you a specific number, Mr. Whitney. Thousands.
Thank you, Mr. Bracken. Those are all the questions I have for you.
Thank you, Ms. Jones. Anything else?
No, Your Honor.
Mr. Bracken, thank you for your time and your testimony. To you and your family, a safe and healthy holiday. You can drop off the call. And well, actually, before you do, let me just ask you one last question, please. Were you watching the hearing up to the point in time that you were called, or did we get you on just right when it was your turn?
Oh no, I was on earlier today. I've watched previous hearings, hit and miss. Right.
So you know as much about this whole case as any one of us on this call.
I pretty much do.
All right, good. Well, you heard witnesses for the plaintiff, Heather Boyd, Stephen Kolznick, and then Greg Doherty. And then you heard me ask some tough questions of Ms. Allander, and you already heard me thank her for her work and what a difficult job she's got right now. And you probably had as well through September 11. But would you agree with the court that, hearing what the situation is of Ms. Boyd, Mr. Kolznick, and Mr. Doherty, they ought to have been paid or captured by now under the court's order. Is that fair, or do you maintain that based on what happened with their cases, the D.E.T.R was in its right not to have paid them fully by now?
Yeah, we're with all due respect, sir, we're going to agree to disagree on that. I think there, initially on Ms. Boyd, regarding Ms. Boyd, I think there were tells or hallmarks of possibly misrepresentation or fraudulent responses for claim filing. Certainly that had to be investigated. Certainly she was due her opportunity to provide information upon request and refute that belief. And I acknowledge that. Based on our inability to get to all of these people, that wasn't done for whatever reason. Certainly it's not something that we feel good about. Regarding the next individual who had, I can't recall his name now.
Kolznick, yeah, the umpire.
Right, correct. He had, my understanding is that, sir, he had eligibility for an alternate base period claim effective April 5th. That was communicated to him. It was communicated in the determination that he needed to contact the agency D.E.T.R to file that claim. He testified that he attempted to do that. He didn't complete the claim. That's why it fell off and went away. I just wanted to put that on the record. That claim was not completed by him, sir. That wasn't officially completed. So that's why claims go away within a certain amount of time if they don't do what they're requested to do. He was requested to contact the agency. Certainly an individual that's desirous of receiving unemployment insurance benefits should continue to make reasonable attempts to contact the agency. We do know, Your Honor, that There were thousands and thousands of claimants that got in each week to talk to a call center representative regarding their unemployment insurance claim. That's fact. That information has probably been stipulated or can be provided to the court. So do you have to continue to do some due diligence to get in and talk to somebody? Yes. Is it difficult? Yes. Were we overwhelmed? Yes, sir. But he was communicated to file that regular UI claim, which we were mandated by the Department of Labor to pay him under that program. Regarding the last individual, my understanding of that claim is, sir, is that he had regular UI eligibility in the state of California. He had wages reported from an employer in the state of California. We have seen evidence, sir, of multiple claimants in the P.U.A program that are not only filing Nevada P.U.A and receiving P.U.A benefits, they're receiving regular UI benefits in various other states and receiving P.U.A benefits in various other states at the same time. Obviously, that's
fraud. That's fraud.
That's fraud. So I'm not saying that in this individual's case, but I know that he was told in his determination, sir, that he needed to contact California to file a California unemployment insurance claim. So I mean, that's my understanding of these claims, sir. Other than that, I don't have any other detail to those, but we were doing our best to be in compliance, not only with your orders, sir, the mandate of the court, but also to be in compliance with our other master, in a sense, the U.S. Department of Labor. It's
okay. I appreciate your response and the candor, and you're right. We're probably going to have to agree to disagree, at least on part of what you just said. And I understand there's in the minds of the state here, there's a tug of war or a tension between the court's order of mandate, and Department of Labor guidance. Of course, the court took that into account in advance of issuing its order, and took into account its understanding of federal law, both legislative and judicial. So fair enough. But I appreciate you answering the court's question. All right, before you drop off, Mr. Whitney, based on the court's last question and the witness's response, do you have any additional questions you'd like to ask him?
No, thank you, Your Honor.
Ms. Jones?
No, thank you, Your Honor.
All right, thank you very much. Sir, again, a happy holiday and safe to you and your family. You can drop off the call. Mr. Whitney, if you would please call the state's next witness.
Thank you, Your Honor. We would call Mr. David Schmidt as the state's next witness.
Okay.
Your Honor, Mr. Schmidt has joined as a panelist.
Thank you very much, Mr. Schmidt. Good afternoon. Can you hear the court?
Yes, sir.
All right, nice to see you again. Ms. Clerk, if you would please administer the oath of witness to Mr. Schmidt.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I couldn't quite hear you, Mr. Schmidt. Did you say I do? All right, thank you very much. Mr. Whitney, you may proceed.
Thank you, Your Honor. Mr. Schmidt, would you please state and spell your last name for the record?
My last name is Schmidt, S-C-H-M-I-D-T.
And Mr. Schmidt, where are you employed?
I am employed in the Research and Analysis Bureau of D.E.T.R.
How long have you been employed with the Research and Analysis Bureau?
I've been with D.E.T.R for a total of 15 years, in my current position for about 3 years, and with the Research and Analysis Bureau for about 14 years total.
Now, what are your main job duties and responsibilities?
So as the Chief Economist of the Research and Analysis Bureau, I'm the head of the Research and Analysis Bureau, which is a separate division within D.E.T.R from the Employment Security Division. Also, from mid-March to June 4th, I worked within ESD as acting Deputy Administrator for UI. Within my current position, I manage the Research and Analysis Bureau, and we provide data analysis and support for other divisions within D.E.T.R, including reporting and data validation for the unemployment insurance program. I also work in cooperation with U.S. Bureau of Labor Statistics to produce and publish labor market information, including unemployment and employment data, and work in cooperation with the Department of Labor to produce data reports, analysis, and projections related to Nevada's workforce.
And Mr. Schmidt, you're familiar with the court's July 22nd order of mandate in this case, correct?
Yes, I am.
Chief Ott, could you please put up exhibit number 17?
Has there been is 17 admitted? Is there an objection, or am I good to share, Your Honor?
Is there any objection from plaintiffs to Exhibit 17?
None.
It's admitted and you may publish.
Thank you, Your Honor.
Mr. Schmidt, did you create Exhibit 17? Or
Yes, I did earlier this week.
now, can you please tell us, just looking at what does page 1 of the exhibit represent?
This report takes a look at all P.U.A claims to roughly November 23rd that have received payment at some point, then had payment stop, and that where that stop was due to denial on a specific issue. In this case, it would be the status code was a disqualified week, which means there was a determination on a particular issue. So it's everyone who had received payment and then did not receive at least 1 week of benefits due to a denied issue.
Well, let me make sure I'm understanding. So the numbers at the right should add up to 100%. Is that correct?
Yes, in some previous versions of a similar attempt to talk about these sort of issues that we have, I went through and did every issue on every claim, and so the totals added up to more than 100%. For this particular report, in an attempt to classify it and make it a little bit more understandable, I went through and there, you see the footnote at the bottom of this page, and that says the order in which I stopped counting. So if I ran into an issue code of 750, I counted it in the 750 group and then did not count it in any subsequent groups. And then 746, 261, 753, and 751. And so this represents the first of that list of issues that had a denial on a claim that had payment stop where payment had previously begun.
All right. So, and before Mr. Whitney asks you another question, I want to just follow up. So, for example, that very first line item, 750 people, code issue 750, with almost 10,000 people representing 44 2/3% of the whole group, started receiving payments, and then it was stopped because the Unemployment Security Division learned or believed or discovered that the person was eligible for regular unemployment insurance or benefits from another state. Is that fair?
Yes, Your Honor.
Now, again, I don't want to sort of argue philosophically, but somebody had to give a directive at D.E.T.R not to pay these people, even though the court's the court's order of mandate didn't directly capture that bucket of people. It didn't say, don't pay these people once you've started if they have UI eligibility still in Nevada. It didn't say, don't pay these people if you have UI or any other employment benefits available in another state. It didn't say that. My order did not say that. Again, this is the unique group of people that had payments begin, not the people who were applying and hadn't yet received benefits, but people who received a benefit and then had it stopped. And I've heard from several people that the thinking was that the Department of Labor guidance required that failure to abide that would jeopardize the state's funding, that might subject the state to sanctions or punishment, or worst case scenario, have to disgorge money that it had already received from the federal government. But yet, this court's order took that into account before, and that's why the court's order was tailored the way it was. So somebody at the state had to have made the decision, either unilaterally or collaboratively, not to pay these people. Mr. Schmidt, were you in any meeting, discussion, email chain, other than with counsel, where that was brought up and somebody in your presence decided not to pay those people? And if so, who was it?
I believe that authority would rest with the Employment Security Division administrator. I know that there was discussion with one of the administrators on that point and whether payment should issue for these people.
Okay, were you in that meeting or on the call or the Zoom call?
I know that it came up. I don't remember exactly when or where.
Okay, who was the administrator at the time?
At the time, it was Administrator Goff.
And what's your memory of what the discussion was? Again, other than in the presence of a Deputy Attorney General or other counsel that was representing the state.
As close as I could come would be that in paying those people would be in violation of the Department of Labor's guidance, and that we needed to follow that. But I can't really get into the specifics. It's been a while. I'm sorry.
All right, fair enough. Thank you. Mr. Whitney, you may proceed. Thank you, Mr. Schmidt.
Thank you, Your Honor. If you turn to the second and third page of Exhibit 17, can you please tell us what do those two pages represent or show?
Yes, pages 2 and 3 both are very similar, except these deal with people who had payments start and then payments stop, but it was not due to an issue that had a denial code on it. Rather, it's an unresolved or open issue. And so a lot of the same codes will pop up. Sometimes an issue will be flagged as one issue, but resolved as a different type of issue. So there is a larger group here. So this is similar to the first page, except these are issues that were unresolved and still open, as opposed to issues that had a denial on them. Because an issue may get resolved as a different issue than where it's initially established, this is a longer list, but that is the key difference. And so these two lists, as far as I can tell, should be mutually exclusive. So someone that's on the unpaid due to denial for a particular week won't also be counted for that week as someone with an open issue. And except in the case where a denial is only covering a limited number of weeks, it should be generally mutually exclusive across all claimants. And so I think that adding together the two reports gives you a larger picture of issues that are preventing payment to people who had been previously paid.
Okay, Mr. Whitney, again, I'm going to exercise the court's prerogative here. I have a few more questions for Mr. Schmidt. Mr. Schmidt, can we go back and please, Mr. Whitney, excuse me, Mr. Ott, would you go back to the first page of Exhibit 17 again? Thank you. All right, so Mr. Schmidt, I asked you about the 9,841 people that the Unemployment Security Division believed had eligibility in other programs, even though they started to be paid. The next bucket looks to the court like these are ones where there was some strong belief that fraud activity was ongoing. Is that fair, a fair characterization?
I think that's representative of how this issue typically gets used, though someone from the program might have a little bit different flavor to it.
All right, fair enough. Then how about the third bucket, the one with 3,916 people? The headline of does not meet eligibility requirements specified in UIPL 1620. And so, for example, the unemployment status is not affected by the pandemic. They were unemployed before the pandemic, et cetera, et cetera. Those 4 bullet points. And then even underneath those, some related issues, unable to verify identity, things like that.
Yeah, so this does have a number of different reasons why this code would be used to flag the denial. As you indicated, there are a number of different ways, and this is a list of explanations that I got from the program, so I can't go into too much detail, but I do know that some examples would be someone who provided in their claim that For example, they became unemployed prior to the start of the pandemic, or they were unemployed for a reason that was
Okay, I understand that. And so let's focus on those. Let's suppose the Unemployment Security Division learned or believed that the person's employment status was not affected by COVID-19. So if somebody initially applied for benefits and the determination was made that their employment status was unaffected by the pandemic, they wouldn't be eligible for benefits. But what about those people that had benefits begin and then later D.E.T.R determined that the employment status was not affected by COVID-19? Are you suggesting that somewhere in the 3,916 people are several people who fall into that category? Because again, referencing back to the court's order of mandate, that wasn't one of the criteria that the state could utilize to stop payments, right?
That is a possibility, but because this is such a broad group, I cannot say with certainty how many people are in one reason or another reason. How many of them are in that particular...
Well, it's under the P.U.A. eligibility header on the left, unlike above it, where it says investigation case special project, which to the court is code for this looks like it could be fraud.
That would be true. However, I believe looking at, look at my own copy here.
Well, P.U.A.
in the way that I reported this,
yes.
Because I flagged someone in this group prior to the 261 group, I did 750, then 746, then 261. It's possible, even though there's more 261s overall, that someone who had both a 746 and a 261 denial would be counted in the 746 group and not the 261 group. So the 261 could be larger and the 746 smaller. That is an artifact of the way that I compiled these particular numbers. It would certainly be possible to do so differently. I would just have to tweak the code a little.
Well, okay, so thank you. But again, and you know, what I'm trying to get a sense is, does the state, does the administrator, Kefrata, do the other senior administrators, are they in line with the concept that if there's even a single person, not 3,916, but just one, who was receiving benefits and later had it stopped because the employment status was determined not to have been affected by COVID-19, that they should have had them restart because the court ordered it? That's what I want to try to understand. Do you understand differently, Mr. Schmidt?
That seems correct to me, though I would, add the caveat that I'm not a part of the Employment Security Division, and so I don't know the specific implementation of how these have been used, but I think your explanation sounds consistent with your order as I understand it.
All right, fair enough. Mr. Whitney, please continue.
Thank you, Your Honor. So as of approximately late November, when you generated the Exhibit 17 with the data you had, how many people, can you tell us how many people then would have been covered by the court's order?
So the maximum potential number of people, I just have to pull up my notes on this. I think the maximum number of people who had received payment at some point was 131,207 P.U.A. claims so far. Of those, 33,777, the total of the 11,741 and the 20,000 something number, 22,000 something number for the denial list. Adding together, that's, I think, the total number of unique applications that have been unpaid at least 1 week after July 10th, which is when I started counting this. So 33,777 unique applications, a total of a little under 270,000 individual weeks of benefits due to either an open issue or a denial on their claim. I could also include for those people, the total number who had excess earnings or had no claim filed. I had 26,117 unique applications, and 84,816 individual weeks of benefits that had previously been paid and were unpaid due to excess earnings, and a total of 86,172 unique applications and 1,122,293 individual weeks of benefits from July 11th through November 14th due to having no weekly claim on file for that week. And I did go back a week for that to avoid overcounting because my data is only a couple of days after November 21st, and I didn't want to inflate that for people who had just not happened to file for the most recent week of benefits yet.
All right, well, what's the bottom number? I mean, because as we all know, if the applicant didn't file for weekly benefits, they're not captured by the court's order. If they had earnings in excess of what would otherwise qualify them for benefits, they're not captured by the court's order. If the state believes that it has some very, very strong hallmarks of fraud or tells, then they're not captured by the court's order. And finally, if they've been afforded an opportunity to be heard because the fraud was directed, the concern was directed to them, and they had an opportunity to respond and be heard, or otherwise have an appeal set and heard, they're not captured by the court's order. But the rest of the people, arguably are captured by the court's order. So, Mr. Schmidt, is that otherwise captured by the court's order, the 33,000, or is it some subset of that?
I believe the 33,777 would be the group that has to be looked at. What I can't say just by looking at the individual issue codes, as I think you've got a flavor of here, is whether that issue code represents having clear and convincing evidence of fraud. Not looking at the individual claims, I wouldn't want to make that judgment call. I have been involved in trying to help query groups of people, like those that had not submitted documents, but that call, being a separate division of D.E.T.R, is not one that I would want to make, but I would believe that it is a subset of that 33,777 applications.
Well, even if
they had clear and convincing evidence of fraud or had an opportunity to be heard or not.
Okay, thank you. Even if it's all 8,164 of the people in issue code 261, and even if we were to add all the people in 746 issue code of 3,916, because there appears to the court to be some overlap with the investigation case special project, that puts us up to 12,000. That still leaves 21,000 people. And so it's of concern.
Your Honor, if I may.
Go ahead.
To those two numbers you just cited, I would also look at the unresolved issue lists because those same issue codes, the 261, the 746 is pretty small on that one, but 261 in particular, they do appear in multiple places, and so I would include that as you're looking at that.
Well, now, okay, so thank you for pointing that out. So then the number grows fairly significantly. Then of the 33,000 that are unpaid, grows arguably to 20,000 people out of the 33. That still leaves 13,000 people that, again, depending on your view of the court's order and the requirements of the law in light of the tension, which the court's not conceding that its order violates or even gets close to the line directing the state of Nevada to do anything inconsistent with the Department of Labor guidance. That would be the farthest thing from the court's mind, and the court would have no intention of doing that for myriad reasons. That would jeopardize hundreds of thousands of people that are being paid without issue. So having said that, even if the court were convinced that there are strong indicia, clear and convincing indicia of fraud or hallmarks of fraud, that still leaves more than 10,000 people that from where the court's sitting should have been captured by the court's order that may not have been at this point. If I'm understanding this correctly. All right, Mr. Whitney, please continue.
Thank you, Your Honor. want to kind of shift gears a little bit.
And I want to remind everyone, I do have a hard stop at 5 o'clock today. So we're going to be done with this hearing. So let's make sure we save time for argument, at least between 4:30 and 5, and we get through all the witnesses no later than 4:30, and that's with a 15-minute break coming up about 3 o'clock.
Thank you, Your Honor. Didn't kind of forget the time sometimes. Shift gears a little bit, Mr. Schmidt, and there was a mention by the court, actually, I think he mentioned it, some of the people that had worked for D.E.T.R in the past. Is Administrator Goss still employed by D.E.T.R?
No.
I'm sorry, was that a no?
Correct, no.
Do you know when she stopped working for D.E.T.R?
I believe it was around Labor Day weekend, but I don't have a specific date.
And how about how about Dennis Perea? Is he still employed by D.E.T.R?
No.
Do you know approximately when he left work for D.E.T.R?
I believe that was around mid-July.
And how about Heather Korbolik? Is she still employed by D.E.T.R?
No.
Do you know approximately when she stopped working for D.E.T.R?
That was mid to late June.
In your opinion, is D.E.T.R doing everything it can to comply with the court's order of mandate while still trying to follow USDOL guidance?
With that last caveat, I would say yes. I think that there is a difference of opinion within the Employment Security Division about the provisions of the P.U.A program regarding program eligibility and other programs in particular. But I know that they are working hard trying to get through as many claims as possible, and the sheer volume of P.U.A claims that, as well as regular unemployment insurance claims, to get all of that processed and to try to get benefits to people, to get them into the proper programs, and to get benefits out where necessary. I know I've been at work trying to provide queries, and Mr. Bracken alluded to this, but trying to pull data on the number of claims that had been paid and then were unpaid, which I've also heard here called a start-stop. I tend to say been paid, unpaid, but I was looking back through my files and I had one from July 28th trying to say, where are we right now? Who are all of the claims that are left that are in this group? So that I could get over to the Employment Security Division so they could work on it. And whether it's running queries, trying to find groups of claimants, overall aggregate totals, that's the side of it that I've been on since coming back to this position full time on June 4th, trying to help support with the data as much as possible their efforts to get benefits to everyone who deserves them and keep benefits from going to people who don't. But that's my perspective on their efforts.
Thank you, Mr. Schmidt. I believe those are all the questions I have, Your Honor.
Thank you, Ms. Jones.
Thank you, Mr. Schmidt. Do you have any knowledge as to whether the current D.E.T.R administration ratified Ms. Gau's positions about payment?
I do not. I have not been involved in those conversations since that time.
The judge does a very good job of breaking down the numbers. I was wondering if you could provide a number of people in that 33,777 who have an in-progress claim and are unable to appeal.
That I don't know. The appeals data is one that I haven't dug into very much yet. As far as in progress or active issues, that would probably align to at least some degree with the page 2 and 3 of the exhibit, those who are unpaid at least 1 week due to an unresolved issue. However, what may or may not be causing issues with filing an appeal, I can't talk about that.
And since that exhibit went away, can you tell me what, so you had page, could you tell me about how many people they were?
The total people who were stopped due to an unresolved issue was 11,741 claims.
Okay, thank you. No further questions.
All right, thank you very much. Mr. Schmidt, thank you for your time. The court excuses you from the remainder of this hearing. Of course, you're free to watch the rest of it. And to you and your family, a happy, healthy holiday season.